Good morning, all of brave ones who have managed to reach here in time despite such heavy fog. I had problem reaching because the traffic was pretty bad. So we already had a lot of turbulence. Very befitting the topic this morning. The nature did play a role. Well, as my friend Mr. Lakshmi Kumaran says, turbulence is good. Surely turbulence is good, but the quicker you steer the aircraft out of the turbulence, the better it is for the passengers. It requires a good captain to steer you out, because there will always be two sides arguing two different positions, like any case. But the question which I ask myself, and which we all of us ask ourselves, is there a conflict? That's a moot question. Or there is an overlap which can be harmoniously construed, where we can safely avoid conflict. My understanding is that there is no conflict. If we go deeper into the law, there is an overlap, but there is no conflict. The legislature, in its wisdom, does not create laws which conflict with each other. The conflict arises in the interpretation. When you have different sides with their vested interests trying to interpret them according to their convenience, and that's where the court's role come into play. Now here, I would say the conflict becomes a little bit more apparent because you have two different bodies dealing with it. So it's not that you only have a court, but you have a competition commission. And when you have two different authorities dealing with the same issue, then a little bit of conflict is bound to occur. I would say, therefore, in order to avoid conflict, it's not only the litigants who have to, or the lawyers who are interpreting the law in the court of law, who have to play a role, but even the courts and the authorities have to respect each other's jurisdiction and avoid arriving at a conflict. So my effort here is going to be to take you through some of the salient features and explain in my humble view as to how the courts or the commissions have dealt with the issue, and what are the issues which we are going to be facing in future, and how we can avoid conflicting situations, and how, in fact, IPR and the Competition Act both are for the welfare of the consumers and for the public interest by and large. So, with that background, if I may take you through my presentation quickly, as we don't have much time, let's see what are the areas of conflict between the two laws. So you have competition law, which curbs monopolies, but IPR creates monopolies. You have competition law, which encourages competition. IPR restricts competition. Competition law controls abuse of dominant position. IPR encourages you to use your IPR to reach a dominant position. Competition law prevents anti-competitive trade practices. IPR prevents imitation of innovations and creations. Ultimately, both of them lead to protecting the consumer welfare and the consumer interest. Anti-competitive because the consumer must benefit from the competition. And IPR prevents imitations or misuse of IPR of somebody else, so that the IPR holder can exploit the innovation and the consumers can be prevented from deception in case of trademarks. So to that extent, they do prescribe different rights and obligations as against each other, and they do appear to be an antithesis of each other, but ultimate objective is the same. Now, we talk about the jurisdiction of the Competition Commission. Some of the relevant provisions which I have quoted here, if you will notice, Section 60 of the Competition Commission says that this act will have an overriding effect. Therefore, can you go to the Competition Commission and say that you cannot decide a particular issue because of the Patents Act or the Trademarks Act or the Copyright Act or whatever any other act is? The Competition Commission can always rely upon Section 60 to say, no, but this act will override, provided there is a conflict, as I also show that there is no conflict in a while. Now, Section 61 of the Competition Act, again, as you will see, it says excludes the jurisdiction of the civil courts. So no civil court shall have jurisdiction to entertain any suit or proceedings in respect of matters which the Commission or Appellate Tribunal is empowered by or under this act to determine, and no injunction can be granted by any court against such action. And then, of course, we have Section 62, which says the provision of this act is in addition. So the jurisdiction of the Competition Commission is well defined under the act. Now you have instances, so the vertical and the horizontal anti-competitive practices are surely barred under Section 3 and Section 3.3 and 3.4. There is a clear exception under Section 3.5 that this will not come in your way to enforce your IPR right, but this is with a caveat. Reasonable conditions are only permitted. So the moment you impose conditions which are unreasonable, and as you have seen the previous Section 60 and 62, the Competition Commission surely will have a jurisdiction to interfere and question the reasonableness of your conditions. Now, even as far as, so the Section 3 has a provision which says that it will not apply to the various IPR laws except to the extent of reasonable condition, but Section 4 has no such limitation. Section 4 is, excuse me, all pervasive and says that if you abuse your dominant position using your IPR, then the field is wide open to the Competition Commission to question you and decide as to why you are indulging into an anti-competitive practice. The bottom line is unfair or discriminatory. Anything which is unfair or discriminatory is an issue of the examination. Now, there are inbuilt provisions under the IPR law which I have briefly touched here. So you have the Patent Act and you have the Designs Act, the Trademarks Act. All the acts, they do recognize anti-competitive practices, and they make it very clear that that is not something which is permitted under those acts. So you can't say that an IPR gives you an absolute right. To that extent, it is consistent with what is being prohibited under the Competition Act. Competition Act is much wider. The practices which are prohibited under the IPR laws are much, much narrower. They don't deal with the IPR, they deal with you're tying up your IPR with non-IPR rights and obligations and using your IPR to abuse them. Now, if we examine the case study, then basically over the last 3 years or 4 years, as the courts have dealt with 3 issues which really arise, which are at the moment also being debated: jurisdiction, injunctive relief, and what is the rate of royalty. We can summarize all the judgments which have so far come into these 3 key issues which have dominated the courts and which are still being discussed. Now, I'll briefly go through the case law. So you have had this case of a Super Cassette Industries where the royalty which was pleaded, which was sought, was not based on the repertoire which is being sought to be used, but on the time frame. So Super Cassette told HT Media, you can use my songs, but you're not going to pay me for each song. You're going to pay me on an hourly rate, whether you use the song or you don't use the song. Now, HT Media went to the Copyright Board and said, please fix the royalty. And HT Media went to the Competition Commission and said, Super Cassette is abusing the dominant position